Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be with you for another hour. We have been hot on the trail in the McStay family murder case. Charles Merritt on trial for his life. As you guys know, jury instructions are being given to the jury right now, the preliminary instructions prior to the closings of the prosecution and the defense in this very long and exhaustively argued case. I'm going to be bringing another guest on because my boy Gene Rossi went out at 2 o'clock, so we're going to have another great guest that's going to be amazing to give us some insights, and I'm looking forward to it. But first, I want to go to what is the pucker time in a trial, and there's many of them, to be honest with you, but it's the ultimate one. It's when the verdict is coming in. It's out of your hands, and you're waiting, and you're looking at the jurors. Are they looking at you, not looking at you? What do they look like? You're doing all sorts of stupid things that really don't make a difference because you have to wait till they actually render. Well, there you see a very visible reaction by the defendant as he's rolling and closing his eyes when the verdict is being read. He was obviously surprised. Now, you didn't see a big reaction from the defense lawyers, but as we showed you earlier when they gave their press conference, they were absolutely devastated and saying that they believe an innocent man was convicted. My next guest, Dmitry Gorin. Let me give you a little bit about this guy's credentials, okay? Senior Deputy District Attorney in Los Angeles for 10 years, where he fought gang cases, murder cases, sex cases, narco cases, as well as white-collar cases. He's a criminal defense attorney. He's handled many high-profile cases, many of which have appeared on the major networks like ABC and NBC. He's also an adjunct professor at Pepperdine Law School, published numerous articles, and if I have this right, you may actually, Dimitri, have actually done the California Criminal Law and Procedure Practice Manual for the whole state?
Yes, actually one of the grand jury chapters in that book I've been authoring for many years.
Wow, that's very impressive. You know why I like that? Because you're a multi-trick pony there. You got that trial experience in the courtroom, but you're a man that knows the law, and that's a powerful combination. So welcome, Dimitri, to the show. It's the first time I've had you on.
Thank you for having me.
Yeah, listen, I want to ask you, Gene Rossi and myself were talking about what we thought was a very interesting jury instruction that the judge gave just prior to the closing statements in the case that went like this. Any lingering doubt they may have had with regard to the guilt phase of the case, they may take into consideration when making a decision as to whether to give the death penalty or life without parole. Now, I've handled death penalty cases in my career. I've never heard that instruction, but a very powerful instruction for the defense, don't you think?
It is. I have handled special circumstance cases and actually litigated a death penalty case about 20 years ago in Los Angeles. I agree. It is a powerful instruction for the jury and for the defendant. It's just difficult for me in this very serious, horrific case to believe this defendant is going to get anything other than the death penalty.
Yeah, Dimitri, you're on board with where I was at. In my mind, and I kind of agree that there can always be, when I've picked a death-qualified jury, despite the fact that every juror says that they could follow the law and impose the death penalty, when they ultimately have to make the decision individually, and that instruction is given, both collectively, all of you have to agree as to the aggravating special circumstances, but each individual has to believe that death is the appropriate sentence. You can get some people where that is just too heavy a burden, but short of that, if there's a case that screams out for the death penalty, if they're relatively convinced Charles Merritt did it, then I don't see how killing two kids and a mom and a dad aren't going to qualify.
I agree. This is one of the most horrific murder cases I have seen. And I think the jury took that into consideration before actually voting for guilt or innocence in this case. When they came back with a guilty verdict, I was very surprised. Mm-hmm. And I want to tell you, when they were in that jury room, I bet you they were considering the death penalty even before reaching the verdict. So I think they need to come up. If I was the defense attorney on this just tough case, unless there was some sort of mental health issue or some other significant mitigating factor, I would not be feeling very good right now about my chances with this death verdict.
I got two questions I need to know from your expertise being on both sides of the fence. The first is me being a prosecutor and having tried far more cases as a prosecutor and defense lawyer. I find it anathema. I am agitated and angry at the idea that 3 DNA profiles are found at that gravesite and the prosecutors refuse to put them through the CODIS system. And I'm also upset that they tried to limit the testimony of third-party guilt, of which the judge let some in but not all of it. To me, it's about getting it right. You have a bollocks crime scene, a horrible police investigation, evidence lost and destroyed, a murder that supposedly happened in the house. Oh, wait a minute, maybe it didn't happen in the house. But can you explain to me any justification in your mind, sir, as to why the prosecutors would not run that DNA?
There's no justification. When I was a district attorney, especially on a case of this magnitude, you want to make sure every I is dotted, every T is crossed, every stone is upturned, so that you know for sure who committed this crime. If there are other suspects, you got to eliminate them. You're trying to put a man to death. And I agree with you. It is an anathema when the government doesn't do everything it should do. And quite frankly, I think it will cause a verdict on appeal to maybe be reversed for insufficiency of the evidence or some sort of misconduct by the government. I think the government should not leave any lingering doubts in the mind of the public. And also, it's like they want to win so much. They're going to do everything they can to win, but justice sometimes gets forgotten.
I agree with that. And I led an agency for 6 years, and it was always about the first and most primary point of view in any case I've ever tried, of which never one where I got a conviction that I ever think that the person didn't do it. And I tried some tough cases, but I believe that they were the actual perpetrators. And what bothers me is that you can't grant immunity as a defense lawyer, so you lose witnesses. You can't have access to the state database systems like the CODIS system. We need to be a place in this country where they're talking about criminal justice reform, where the defense has a fighting shot when they're confronted by prosecutors who, in my opinion, are not following their oath of office. And they need to make sure that we have access to that. Now, here's another thing I just want to throw out, and you can respond to any of this. They actually put a witness on the stand that said, oh, the DNA you find out in the desert, there's dust and there's garbage that flies around, and, you really can't trust it. Dimitri, can you believe this? If they didn't have a suspect, you could be sure as heck they'd be running those DNA profiles.
Yeah, I agree. They should have run all the possible profiles. I would have had my detectives do that if I was the prosecutor on the case. And I was a district attorney for 12 years, prosecuting some of the highest profile, most unusual cases here in Los Angeles. And I've defended many as well. I've had the opportunity to do that. I don't understand why they didn't do that. It seems to me they wanted to get a conviction. They got their conviction. But you know what? That's why you have the courts of appeal. That's why you have a motion for new trial. And the defense is going to add all that up and, raise doubt and say, listen, this conviction wasn't correct. A different verdict would have reached because these other steps were not taken. So, and especially in these such serious cases, you don't want to have them reversed an appeal after years of trying to convict somebody. I don't. Yeah.
You've been around the block. And people are talking about criminal justice reform, and I say, you guys can have all the statistics you want and all this stuff. We've really lived the life of what's going on. And I think, and I told a very high-level official one time what the biggest problem is, the philosophy of prosecution has changed. When I was a young pup prosecutor, if I ever got caught in a discovery violation or not having given the defense pretty much open file discovery or withheld something or did any kind of game playing or didn't run DNA profiles or things of that nature, I would not have a job. But today, more and more prosecutors are getting away with it without any consequences, and to your point, care more about the conviction as opposed to the philosophy I lived under, which was the conviction isn't the end of the story. If your case comes back on appeal because you didn't do something right, you're not going to have a job either. What's happening here?
I want to say it's rare. I mean, I've been doing this 25 years, and most of the prosecutors I come in contact with are highly ethical. They do their job. But in high-profile cases, the challenge is you have so much pressure to win that sometimes you may cut corners. I'm sure these are the best prosecutors in the county. I'm sure they feel they've done everything ethically and have, followed the rules. But we as the public have the lingering questions. Hey, why wasn't CODIS run? Hey, why weren't these other things done? And so as a prosecutor, you want to convince the jury of proof beyond, proof beyond a reasonable doubt, get a conviction. But you also want to make the public feel that, hey, we've treated the defendant fairly. And when you leave these lingering questions about why things weren't done or were done and are not playing fairly and are not playing by the book, it leaves us as the public concerned, hey, this man might not have gotten a fair trial. And that's why we have a verdict on such weak evidence. And there were other suspects, right? So I agree with you. I think most prosecutors, though, are fair. But when you have high-profile pressure, people sometimes will do things they won't do otherwise.
Yeah, okay. Well stated, Dimitri. I appreciate your opinion. Thank you, listening, for my half rant. I appreciate it very much because this, as a prosecutor, I believe in prosecutors and what they do. And I do agree with you. Most of them are ethical and doing the right job. But when bad things happen, it affects the entire prosecutorial system because the stain goes on everyone. Okay, so that's part of the prosecution's opening statement in the penalty phase. Dimitri, I'm curious. I've been asking all of our high-powered attorneys that have really been around the block in the courtroom. I find it curious that they put on no mitigation evidence at all in the case. Now, I get they may want to say he's innocent and he didn't do it, and certainly there's a jury charge in the penalty phase where they're going to be able to maybe make that argument, how powerfully or which direction they want to go that way with regard to lingering doubt, I don't know. But anything, good guy stuff, positive things he's done, drug or alcohol history, family, social history. I've seen it all. I've seen more aging out experts that'll talk about the difficulties of life without parole. I don't know, it seems to me that I would have put on as much mitigation as I could and still went for he didn't do it.
I agree. When I heard they weren't putting on much mitigation, I was actually very surprised. Having tried a number of murder cases and also, as I said, a death penalty case, it would, I can't believe they haven't put something on. I'm actually very surprised. Typically, when you're preparing to try a death penalty case, you're gathering mitigating evidence connected to preventing the defendant from being sentenced to death even before trial starts. So whether it's family information, witnesses that can talk about what a good guy you were in school, or like you mentioned, any sort of mental health issues. And so that's something you gather even before you go to trial. And in Los Angeles, I would be presenting that to the district attorney's office even before trial to get them to not pursue the death penalty. So I'm actually quite surprised. And I bet this is one of the only death penalty cases out there where the defense has chosen not to present evidence of mitigation.
Yeah, very well put. And you know what? You just raised something that is so nuanced. And what I tell people, like, how can you be a prosecutor and then be a defense attorney? And I say to people that most of the time what I'm doing in my defense career is, of course, you have a right to a trial if that's what you'd elect to do. And I love trying cases. That's fine with me if a client wants to go there. But a lot of times, from the very minute they step into my office, we do a thing called a mitigation package information sheet. And we have that. I don't care if it's for municipal court or all the way up to the biggies like a homicide case. And we tease out as much positive information we can about the client. And while the charging decisions are being made, I always felt as a prosecutor, I would say, why didn't you present to me the information? We waited all the way to sentencing. I would have taken that into consideration as to what we would have offered as far as the plea is concerned. Set the stage from the beginning to humanize them and mitigate the conduct for a lesser sentence. And that's basically what you're saying you do as well.
On every case, I do that. Even before the case is in court, sometimes we can get cases dropped without charges or some sort of informal diversionary process here in Los Angeles that's available. Even if somebody's arrested, you go to arraignment, case is dropped, or you're not going through the court process, you're going through an informal process. So on all my cases, I do that. But in a death penalty case, to not present evidence of mitigation is unheard of, to me at least. And I agree with you. They're going to be, their argument is lingering doubt, that there's this lingering doubt, irregardless of the mitigation, there's lingering doubt. But also, why wouldn't you present mitigation evidence? Why not talk about his family? Why not talk about his background? Why not talk about what a great guy he was perhaps earlier on in his life? I'm not taking away anything from how serious this case is and how whatever they would do, I think it's still going to be a death decision by this jury. But you got to present this type of information. You may just get one person. Remember, they have to convince all 12 people that an aggravating circumstance exists beyond a reasonable doubt. Right. And maybe one or two may say, wait a minute, this is not a bad guy. The crime is horrific, but why not give him a chance at life rather than imposing the death penalty? And that's why I would try to present mitigation. But of course, we don't know all the attorney-client privilege stuff that was done. We don't know the investigation. We don't know what they have. Maybe they couldn't find a lot. So it's hard to speculate why they're not presenting any mitigation, but it is unheard of.
I've prosecuted some of the worst people you can think of in terms of the quality of the conduct that they committed a murder, and still lawyers were able to find some mitigation, even though it may not have been effective, to at least present. But a great analysis there. Let's listen to a little bit more, though, just jumping ship onto the other side of the prosecutor's opening in this death penalty case. Okay, we're going to just take a real quick break, but before we do that, Dimitri, what are your thoughts so far on how the prosecutor's doing?
Man, it is devastating for the defense here. He is putting in the foundation to explain that Mr. Merritt is in his 50s. He had really, how could he have possibly done this? And it's just devastating for the defense. I think he's doing his job. He's laying the foundation to get a death verdict. And I think the defense is going to, has its hands full with this advocacy. But,
okay,
I think the prosecution is what he wants. Once they got their verdicts, the death verdict is an afterthought.
He's hitting. I'm sorry to cut you off, Dimitri. He's hitting the brutality piece, which is the most important piece for the prosecution. All right, prosecutor giving a very passionate statement. He's worried about that lingering doubt charge. We've been talking about that with the guests all day long. Proof beyond a reasonable doubt and lingering doubt are two different things. That's very favorable for the defense, and the prosecution's trying to end run it before the defense gives its closing statements. It has been a fascinating trial, Charles Merritt. We're going to be continuing with the coverage. I want to thank my guest, Dmitry Gorin, for helping us out, as well as Gene Rossi. Michael Bryant's next. Stay with us. We'll be right back.